My Lord, we have not been served with the preliminary objection. I'll associate myself with Mr. Wanyama's position and bring to the attention of the court that when we appeared before you, my Lord, on Friday, we were seeking for conservatory orders. The Law Society of Kenya said that there's a meeting. Out of the meeting, the Vice President of the Law Society of Kenya addressed the media that this is an onslaught similar to the radical surgery. So, my Lord, based on that, the PO has just been filed to keep us busy, glued on the PO, as the radical surgery of storming into courts starts today. There is utmost urgency that order and sanity is put in place. And on our part, we shall be seeking that the court grant some reliefs, even as we proceed with the PO, because the PO purely is aimed at allowing the Law Society of Kenya actualize their threats to the judicial officers and to the advocates who will be appearing before in court. We also raised an issue whether the president's law firm, the president having called for the boycott, the president having stormed in courts, the president having now representing himself, that is also another issue that needs to be dealt with. That's all, my Lord.
And it is also clear, my Lord, based on the representation by counsel, there is no denial that there is a crisis within the justice sector. And
my Lord, precisely that is what
I didn't interrupt Mr. Kajama when he was making submissions, so he can't be so unfair.
Because these are now statements.
My Lord, even the resolutions that Mr. Kajama has made were never approved by the membership as required under Section 16 of the Law Society of Kenya Act.
I don't think that is right.
Whatever Mr. Kajama and his counsel are doing,
it is not lawful to attempt
they have reduced the Law Society of Kenya to a club of 13 members.
They are not right to be responding at
the LSK Act requires that all resolutions, my Lord, are approved by members at an AGM. This has all been done.
So I may have to mute all of you, and I want to give directions. Because as I have stated, I have heard everyone that needed to be heard as per the procedure. So now it is time for the court to give directions. So I'm not recording anything else from any of you. So please give me a few minutes. I'm doing the directions. So I have considered all the representations made by counsel representing various parties in this matter. And I have taken note of the urgency of the matter having been filed on 27th or about 27th of July and certified urgent, and then directions given on service and hearing. And there is therefore need to hear and dispose of the issues expeditiously. Consequently, I give directions as follows. Number one, that the PO dated 31st of July 2026, which is challenging jurisdiction, shall be heard first. And in that regard, the respondent is hereby directed to serve Mr. Wanyama, who is appearing for the 7th respondent, by close of business today. Number two, respondent shall file and serve submissions on the PO within 7 days from today. Within 7 days from today. Number three, The petitioners and interested parties shall file and serve their written submissions on the PO within 7 days of receipt of the respondents' submissions. The petitioners and interested parties shall file and serve their written submissions on the PO within 7 days of receipt of the respondents' submissions. Number 4, the respondent shall be at liberty to file as supplementary submissions if the need arises, and the same to be filed and served within 7 days of receipt of the petitioners and interested parties' submissions. So 7 days upon receipt of the petitioners and interested parties' submissions, and subject to compliance with all the above directions on filing of submissions, the court will give a ruling on 17th of September. Subject to compliance as by the directions, court will give a ruling on 17th of September. I've also weighed the submissions made, interim conservatory orders, and I've taken note of the affidavit evidence placed before the court. And of course, the court does not operate in isolation. It's also alive to what has been going on within the courts. And for that reason, I've issued or fashioned an order here for purposes of restoring order in the justice system. So this order is in the following terms: that there will be an interim conservatory order restraining the respondent from disrupting and or interfering with court proceedings before the judges and judicial officers mentioned in their communication dated 20th July 2026, or any other judge or judicial officer. Pending, then the court will give further directions on that. So basically, the order will last until 17th of September.
Much
Those are
obliged.
the orders.
Much obliged, my lord. Thank you very much.
Can we just clarify the order, the conservative
Yes.
order, interrupting the court proceedings, if we have
Yes.
the court correctly?
Disrupting or interrupting court proceedings before any court
Disrupt or
is
interrupting
yes.
court proceedings.
Yes.
Thank you.
Most obliged, my lord.
Much obliged, my lord. Thank you very much.
It is clear.